Okay, good evening, everybody, and welcome to our Wednesday evening seminar. Tonight, we are looking at insurance and the JCT contract, and this is led by Mr. Jon Sharp, consultant solicitor at Fletcher Day. Good evening, John.
Good evening, Julie. How are you?
I'm good, thank you. As always, John is happy to answer questions that you may have. You can use the Q&A or chat facility in the bottom toolbar of your screen to raise these, and he will answer as many as possible at the end. Alternatively, if there is something you'd like to raise but not in an open forum, please feel free to email John directly. It's jon.sharp@fletcherday.co.uk. You will see his email at various times on the screen. Please feel free to communicate with him directly on this issue. Okay, John, it's over to you.
Thank you very much, Julie. Good evening, everyone. Insurance and the JCT contract. In order to understand how insurance interacts with the JCT contract, you do need to know a little bit about insurance, and so I hope I won't bore you too much with that. And the second half is much more practical, and I was very much assisted by Phil Lamb of Clear Insurance in preparing those slides, so I'm very grateful to him. That's me. Nothing said about him, the better. I think all the details are on the firm's website. There are three important principles to insurance. Irrespective of the changes in the law, which I will deal with, insurance is a policy of indemnity. It's designed to put the insured back into the position that they were before the insured event took place. So not better, not worse, the same. Now, there are some policies which say new for old, but they're typically on household policies, and that's slightly different. But the basic principle remains that it's a policy of indemnity. It's not a policy of betterment, it's a policy of indemnity. So, as at the time of the insured event, insurance is there to put you back to the same position that you were. Insurance is also a contract between the insured and the insurer. Therefore, the insurance policy terms and conditions are important. Any insured's aim has to be to ensure that it's fully covered for any eventuality. Proper insurance can save businesses. Right, for the last 100 and so years, we were served well by an act called the Marine Insurance Act of 1906. I don't think there was a clause that probably wasn't litigated over at some stage and that there wasn't a judicial ruling on. But the Law Commission thought it was archaic, unclear and unfair, unlike, of course, the Consumer Credit Act, which, of course, is entirely clear and fair. So they decided to reform it. It was particularly important in London because the London insurance market has global influence. It's still the third largest insurance market in the world. So to replace the Marine Insurance Act, three new acts were introduced. The Consumer Insurance Disclosure and Regulations Act of 2012, CIDRA. The Third Parties Rights Against Insurers Act 2010, but that wasn't enacted until 2016, and then the Insurance Act 2015. As an afterthought, there was an insurance provision put into the Enterprise Act. CIDRA, or CIDR as it's become known in the legal profession, I don't know why, was law from 2013, but it only applies to consumer insurance contracts. So it applies to those individuals wholly or mainly unrelated to trade, business or profession. So it's I've got to have motor insurance, I've got to have house contents, I've got to have personal phone insurance. That is what CIDRA applies to. And I don't suspect most of you here will thank me for telling you all about it, so I won't. But the Insurance Act 2015, which was introduced in 2016, applied to all commercial insurance policies commencing on or after the 12th of August 2016. It introduced, and I'll come up to talk about this a bit later, a new duty for all non-consumer insureds to make a fair presentation of the risk. Now, the old law was that basically of full disclosure. Those contracts were described as contracts of uberrimae fidei, to use the old Latin, or utmost good faith. It was designed, and I'll come back to this point in a moment, to reduce the insurer's remedies for breach of the duties of fair presentation. So, let me give you example A. Example A under the old law would be a warehouse being flooded. But you had said to the insurer that the fire alarm would always be working. Mr. Loss Adjuster comes round, he clearly sees there's a flood, but then he looks and finds, oh, fire alarm's not working. I'm not going to pay the claim. Now, the fact that the fire alarm doesn't work wouldn't have stopped the flood, wouldn't have alerted anyone to the flood any earlier, because it's a fire alarm. But nevertheless, it allowed insurers the opportunity to get out of the claim. The new act was supposed to stop that. I'll come back to that point. So what is fair presentation of risk? Well, it's your duty to provide all relevant information. You must now involve all relevant senior management when compiling information for your insurers. So in the old days, there may have been an insurance officer and he filled out all the forms. But no, not now. It's his duty to check with everyone if there are, to see whether there's anything relevant that they know which might affect the insurance policy. Also he's also got to state not only material circumstances that you know, but you ought to have known, bearing in mind the nature of your business and having conducted a reasonable search. I cannot stress enough how much this search issue is. It's not a one-man job anymore. He's got to ask all the right questions, all the right people in the business before he can make a fair presentation of the risk. And you've got to provide that information to the insurer in a reasonably clear and accessible manner. So who's senior management? Anyone who has a key role in making decisions on behalf of the company. So it might be a board member, but it might also be someone who doesn't necessarily have an official role. So site managers, operations managers, logistics managers. What's a material circumstance? Well, it's anything that would influence the judgment of a prudent insurer when he decides whether to accept the risk, and if so, on what terms. So clearly, if you say to an insurer, I'm only taking part in buildings under 50 feet in height, when in fact you're doing more than that, sorry, you're operating at more than that height, that's clearly a factor that's going to influence an insurer. Known or ought to have known, basically common available information that affects your business. So new building regulations. A reasonable search, well, it depends on the nature of your business and the type of insurance that you want to buy and who's best placed to provide that information. So gone are the days where, as I've said, someone sat in an office and signed last year's proposal form. That's not good enough. You've got to ask the right questions. And reasonably clear and accessible, well, it's not going to be put in a carrier bag. But also don't hide key facts amongst large amounts of basically wholly irrelevant material. So, the Insurance Act, if the insured fails to give a fair presentation of the risk, the insurer may avoid the policy as, well, if it was deliberate or reckless. So, in fact, you did 12 buildings last year at a height of over 50 feet. That's clearly something you should have told insurers. That's deliberate. So the insurer can avoid the policy. Not have written the risk. Well, taking the 50 feet example, if you did one building last year and you forgot to tell them. Well, some insurers may not have written the risk, but it's not deliberate, it wasn't reckless. So they can avoid the policy, but they have to give you your premium. Any other breaches? Well, if the insurer were to have imposed additional terms, they are imposed from inception, or if a higher premium was to be charged, then the claim is reduced pro rata by the amount of the higher premium. The AXA default scheme. If your insurers wish to contract out, then they must, if a term is disadvantageous to an insured, take steps to bring it to the insured's attention, ensure the term is clear and unambiguous. It's probably not suitable for reinsurance contracts. I won't bore you with what reinsurance is. But remember, insurers can contract out, but they've got to make those terms available to you and point them out to you. What do you need to think about taking insurance for? Well, don't just think about your JCT contracts. Think about taking out cover for directors and officers. They are responsible for the company's operations, and increasingly legislation is now mandating that directors and officers in certain circumstances can have personal liability. Cyber attacks. I think we all know, it's widely reported that since the pandemic took place, there has been something like a 75% increase in cyber attacks. Think about taking out key man insurance on your key individuals. What happens if you lose one of them? You're going to have to replace it. Taking out key man insurance will at least give you some money so that you can replace that person. Pollution, well, PLI, one event, sudden accidental cover, is sometimes covered. Contractors, all risks. Some policies can cover cleanup costs up to $1 million, but you can, of course, buy site-specific pollution. It's expensive, but think about it if you've got a very polluted site. Professional indemnity is more or less a must, duty of care to others, and avoids the issue of whose design error it was. Now, I'm just going to have said earlier that I'd come back to a point on the question of fair presentation of the risk. Pretty much under the Marine Insurance Act, people knew what you had to do, and that was to disclose just about everything about your business, because if you missed anything, insurers would avoid the policy. Yeah. What the Insurance Act was designed to do, going back to my warehouse flooding example, was to stop insurers avoiding the policy because the fire alarm didn't work. The fact that the fire alarm didn't work didn't stop the flood, wouldn't have helped anyone deal with the flood any earlier. So it was widely assumed that the Insurance Act would be interpreted, I suppose, more in the insured's favour. Unfortunately, that's not the case. QBD just handed down a decision. It's the first one on fair presentation of the risk in a case called Berkshire Assets West London Limited against Berkshire Insurance UK plc. This case concerned business interruption and contractors all risk. Yeah. Now, one of the questions on the proposal form was whether or not any of the directors had been charged with or committed a criminal offence. Now, one gentleman from the company who signed the proposal didn't do what I said to do earlier, which was check. In fact, one director, who was also a director of another company, had been charged with some offences in Malaysia, though it transpired that the charges were all politically motivated and were subsequently dropped. But at the time, that disclosure was not given to insurers. Now, you might think, well, the fact that a director, and he wasn't even a controlling director, he was a minor director, been charged with an offence which was subsequently dropped, how can that possibly affect business interruption insurance and contractors all risk? Well, you'd be wrong if you thought that insurers didn't manage to avoid the policy. They did. They said that non-disclosure of that, the court said non-disclosure of that was fundamental. And further, the courts went on to say that the Marine Insurance Act material circumstances cases, of which there are hundreds, are all still relevant today. So although the law might seem to have changed, it really hasn't. So I would warn everyone that when you're making and submitting your proposal form, be very careful. Don't leave anything out at all, and make sure you have done the checks, because insurers in this case avoided the policy. Even though, frankly, I'm not quite sure how it could have impacted on business interruption and contractors all risk insurance. But the courts found it was a material circumstance. It would have affected an underwriter's judgment, and therefore AXA, in this case, avoided the policy. So be very, very careful. If you're not sure about whether you should disclose something, my advice would always be disclose it. The worst that will happen is that insurers may come back at next renewal and say, you don't need to tell us about that. That's fine, we get it. Or they might say, well, we are going to increase the premium slightly because you've told us that. But the consequences of not telling them far outweigh what might be a slight increase in premium. Also, mind your excesses. Lots of people take out huge excesses on their insurance in order to keep the premium down. Well, that's fine if your business can afford it. But if it can't, difficult one. Is it really worth increasing your excesses to such an extent that if you get a claim, that the business can't afford it? So have a think about that. Also, read your policy wording. Julie and I, for years, for years have been banging on about this. Well, I have been. Julie, take it out of me. But do read your policy wording. It is the contract between you and the insurers. Don't forget to notify insurers of any changes to the risk in any policy year. Okay? Don't assume that you'll be covered if you've said we don't do any work on buildings over 50 foot, if you start suddenly working on buildings that are over 50 foot. Just tell your insurer. So we've been instructed, that's the building 75 foot high, only just above what we normally do. Is it all right? Insurers will probably go, absolutely fine. Thank you very much for letting us know. That's it. But if you don't tell them, they'll avoid. Beware of the loss adjuster. These are very trained people, and they will always come and examine what you're doing. Loss adjusters like businesses that are helping themselves. So, take the warehouse situation. You've had a flood. You're doing your very best to salvage what you can out of the water. You've put everything else high above where the water levels ever rise, and you've done your best to clean up, etc. Loss adjusters like that. they say, well, fine, these people are trying to save their business. They will make recommendations to the insurers that, yes, you need to do this, that, and the other. If they come in and find that you've left everything still floating in the water, they won't be very happy. And also remember that until cover is confirmed, you must act as a prudent uninsured. So don't assume that insurers are going to pay for it. You've still got to do your best to minimize any loss that you may incur. The last caveat I was going to add was the effect of the Enterprise Act. There's been no cases on this yet, but in the Enterprise Act, which has now been put into the Insurance Act, Parliament was trying to do its best to encourage insurers to settle straightforward claims quicker. And there is a provision in there that says if this is a straightforward claim and your insurers are frankly just messing about, so not paying for whatever reason, there is now provision in the Insurance Act that came in through the Enterprise Act, which means that you can recover some damages and potentially interest on any sums that you've lost. I don't know a case where it's actually been brought yet, but it is there. The next slide shows you what the difference is between this is an insurance policy that was taken out for business interruption. Unfortunately, the people that showed me this didn't read it properly. Contractors all risk is at the bottom there, and it says that the total that can be claimed is 2.5 million. That's the total you're going to claim for the whole year. They thought it was every event. No, it wasn't. So don't forget to read your insurance policy carefully. On that particular slide, on the slide before, that was a summary of the policy. This is the policy wording. It's something like 64 pages long. Your policy wording is your contract with your insurer. The summary you get just sets out in nice terms what you're covered for. Actually, what you're covered for is set out in your policy wording. And in this case, this policy wording matched the one I showed you. It's 64 pages long. It needs to be read, regrettably. And there we go. Now, the JCT contract, well, it's been the main form of contract for general construction for 50 plus years now. It's recognised as the standard contract. I don't think any of us would disagree with it. NEC number 4 is a contract, but that's a recent alternative. And of course, there are contract forms for specific areas, such as civil or mechanical engineering. Excuse me. There's also a vast array of contract and subcontract forms and warranties, but we're going to focus for the rest of this talk on the most common JCT contract that you'll encounter, which is the JCT Design and Build 2016. Contract forms are very often amended. If you are going to amend the JCT Design and Build 2016, please, everyone, make the amendments clear so that they're understandable to everyone. Make sure that they're signed so that that indicates that both parties have agreed to them. We get bits of paper attached to it, not signed by anyone, bits scribbled out, not signed by anyone. We get pencil amendments. Please, if you're going to amend it, and it's absolutely fine to do so, please just make them clear. Makes my life an awful lot easier and will save you money. It's a popular procurement method for the following reasons. It's based upon the employer's requirements and the contractor's proposal. Has fixed points of responsibility for construction and design. Neither contract sum or period can be varied unless the employer's requirements are amended. think we all know that. It's popular, and I think we're all used to it. The contractor's design indemnity is set out in clause 2.17, where the design is comprised in the employer's requirements and contractor's proposals. The contractor is responsible for any inadequacy in design. They have the same duty of care as an architect or other professional. Under clause 2.17, the contractor must supply all relevant design documents for retention and use by the employer. And as I've said, the contractor is responsible for any inadequacy in design. Doesn't seem fair, that's what the contract says. This will include designs carried out on behalf of the contractor that form part of the contractor's proposal. This can include any design works carried out by consultants on behalf of the employer that are then novated into the contract. Any claim for possible design defect will land at the contractor's door. The contractor's insurers will have to defend any claim with attendant costs. There might be a route for recovery in negligence if negligence can be proven on the part of any consultant providing a design function. But negligence actions take a long time to go through the courts. Typically, probably 3 to 4 years, because they're complicated. It's difficult to find experts who are prepared to say bad words about another expert in that profession. So don't rely on it. It's the contractor's obligation to insure professional indemnity insurance, and that's set out in clause 6.15. They must effect cover for the sum limit stated in the contract particulars. They must maintain the policy for the period stipulated in the contract particulars. They must provide evidence that they have such insurance in place. The contractor is required to effect cover provided it is available at commercially reasonable rates. This is an important point at the moment. For reasons that I'll come on to in a moment, all insurance premiums in relation to building contracts are going through the roof. When does it become commercially unreasonable? It's a nice question, and it's not been tested by the courts yet. But if it's not the case that you can effect it at reasonable rates, then the contractor must notify the employer and, if possible, seek a resolution. Indemnity and insurance provisions. The provisions are set out in section 6, injury, damage, and insurance. Clause 6.1, contractor's liability, personal injury or death, employers and public liability arising out of the works. Clause 6.2, contractor's liability, loss, injury, or damage to property. It excludes the works and existing structures. That's public liability. Clause 6.3, loss or damage to existing structures. Existing structures do not count as property pursuant to clause 6.2. Similarly, the works do not count as property pursuant to clause 6.2. The property is at the risk of the employer. It's an important point to remember. So if you're going into an existing structure to refurbish it, the insurance position is different. Insurance against personal injury and property damage, contractor's insurance. Clause 6.4, the contractor must insure for the statutory required limit for employer's liability. For any other claims for third-party injury or property damage, there will be a minimum indemnity limit set out in the contract particulars. Excuse me. Clause 6.5.1, contractor's insurance of the employer's liability. The contract particulars set out if this cover is required. Where the works are close to or on a shared wall with a neighbouring property, it is very likely to be recommended. It covers the employer's legal liability, not the contractor's. It covers any expense, liability, loss, claim, or proceedings for which the employer may incur or sustain by reason of injury or damage to any property caused by collapse, subsidence, heave, vibration, weakening, or removal of support, or lowering of groundwater arising out of the carrying out of the works. However, note the exclusions. Again, this goes back to reading your policy wording. The cover specifically excludes any negligent act of the contractor, which might be covered under their public liability, errors or omissions in design, inevitable damage, that which the employer must ensure under clause 6.7c, works or site materials, and war, insurrection, acts of foreign enemies. Cover also specifically excludes any negligent act of the contractor, though that's potentially covered under public liability, errors or omissions in design, inevitable damage, that which the employer must ensure. I just said this, apologies. Pollution or contamination, damages in respect of breach of contract. Quotations obtained are normally obtained on a project-specific basis, and ideally should be placed with the contractor's public liability insurer, avoiding disputes over negligence. Insurance of the works and existing structures. Well, insurance normally offer options A, B, and C, which are set out in Schedule 3 to the contract. In each case, the policy must be in the joint names of the employer and the contractor. In each case, the policy must maintain until practical completion is evidenced by the appropriate certification. Clause 6.78, new build with contractor to ensure works for all risks. Clause 6.7b, new builds with employer to ensure works for all risks. Clause 6.7c, works involving alteration, repair, extension, renovation, maintenance, or repair of an existing property being worked on. Clause 6.71c1, employer to ensure existing building and contents for loss or damage arising out of one of the specified perils, risks. Employer, clause 6.7, clause 2, the employer to ensure works for all risks. And you should always include terrorism. We live in an increasingly safe world, but that may not last, and terrorism, I'm afraid to say, is still there, and cover should always be taken out for terrorist action. Watch out for circumstances where the employer under the contract does not actually own the building being worked on. Say he's a subtenant. Whichever clause applies, subcontractors on site have automatic benefit to certain cover protection under the joint names policy. But as a prudent contractor, you would always want to see that the subcontractor has got insurance for the works that he is about to carry out. And that won't mean just seeing the front cover of his policy to say I'm insured. It may well mean I want to see your policy wording because I want to understand what you're actually covered for. A waiver of subrogation rights or recognition as insured for damage arising out of specified perils till the subcontract works are practically complete. Employer and public liability insurance, JCT contract is not particularly prescriptive. Policy wordings that are available are many and varied. Again, cover must remain in force during the obligation period of the contract. Cover must fully reflect the nature of the work to be undertaken. There must be no types of work exclusion or limitation applicable. Now, be careful when going for this because the nature, status, and security rating of insurers varies enormously. If you want to place your employer's liability abroad, fine, but the chances of me being able to recover from them, especially in some countries, are very limited. And many offshore unrated insurers operate in the UK, so be very careful. There is no point in giving premium to an insurance company that's not going to pay you. And sometimes insurers don't want to pay. And it's bad enough if they're based in the UK. Imagine if you've got one in Russia, Gibraltar, elsewhere in the EU whose legal system is not quite the same as ours. So make sure you've got someone who's going to be responsible for checking the ongoing adequacy of your insurance as well. Going back to my earlier point, make sure that if you carry out new types of work, you are appropriately covered. Joint names insurance, the obligations under clause 6.c often cause problems. The employer under contract might not be able to comply with a specific insurance provision. They may not own or insure the building. Tenant or leaseholder is the most common reason for such problems. The building might not be insured but protects under a risk protection agreement or captive insurance program. The existing builder's owners, the landlord or their insurers might simply refuse to grant the necessary joint names insurance provisions. There may be other occupants of the building of no interest in the contract. A footnote within the JCT contract recommends an alternative insurance schedule clause is drawn up by an insured professional. It's probably right. Professional indemnity insurance, the market for design and build professional insurance is particularly difficult. It has been difficult for some time since we had the tragic events. The implications of the fire at Grenfell have been widespread and significant, and the insurance market still awaits the final decision as to who was responsible. There are many, many theories, including the conspiracy theory, as in it was everyone knew this was going on and no one did anything about it. So they are not looking forward to having to pay the bill for that. The market capacity is reduced and costs have soared. So not as many underwriters are writing this type of business and the cost has gone up. Aggregate limits are being imposed. So instead of having 2.5 million any one project, you're now getting 2.5 million all projects all year. A huge variety of combustibility exclusions for cladding are being imposed. Basically, cladding is not going to be insured. Just not going to be covered. Unless you're prepared to pay a huge price for it. There are, I think, 2 syndicates at Lloyd's that will look at it, but a massive amount of premium. In extreme cases, when I did these slides, it was extreme cases, but now it's far more common. There's a total exclusion relating to combustibility of the entire envelope. It's just anything to do with fire now, they're not interested in. Claims are generally being very strenuously refuted, and insurers are reluctant to grant it. The default position will always be you're not covered. it puts the contractor in a very difficult position. You may well, therefore, as a result, be in breach of contract. Any warrant granted may be affected. And if you have signed documents under a deed, there may well be a long tail liability left on you up to 12 years. So, in terms of conclusions, I think there's probably three. Firstly, don't be fooled by this fair presentation of the risk point, because following on from this case, it doesn't seem to me that there's much change from the old law. So if you are in any doubt at all, then disclose to your insurers. At the very least, speak to your brokers and say, I'm not sure this is relevant, what do you think? But there is going to be very, very little difference between this duty of fair presentation and the old duty of disclosing everything. Also, don't think in that case you recall these were criminal charges. How can that affect a business interest? Well, it did. So just be very careful about that. Secondly, make sure that you do and make all the right inquiries before you submit your proposal form. Don't just think, I know everything, I'm in charge of the business. You don't. You've got to be shown to have checked with everybody else what it is you need. Thirdly, your insurance policy is an ongoing thing throughout the year. If there are going to be changes to it, you're taking on new work, tell your insurers. Think about the types of work that you're going to do. But above all, and I will leave you all on this note, as Julie would expect, read your policy wording to make sure that it's going to cover you for the type of work that you're doing in the event that something goes horribly wrong. Thank you, everyone. That's all I was going to say. Hello, Julie, you're back.
I am indeed. I'm back in the room. Thank you for that, John, and for, as always, never disappointing in the repeating of read your policy wording. It's a comfort to me, I can assure you. If anyone has any questions for John, now is the time to ask. As we said earlier, use the chat or Q&A facility in your toolbar. He'll be glad to answer them. Otherwise, it is jon.sharp@fletcherday.co.uk if you have a specific query or something you don't wish to ask in an open forum. Okay, next week we have the last seminar of the year. It was deferred from earlier in November.
I'm not doing it, Julie, then.
No, you're not doing it, John. There'll be no read your policy wording in that one. Be relieved to learn. 8 a.m.
Is this my last one then, Julie?
It is the last one for the year. Mohammed Haq is rounding up our seminar schedule for this year with the last in his Adjudication Matters series, where he's talking about claiming time and money in adjudication. So if you would like to log in for that, please email me on seminars@fletcherday.co.uk and I will get you booked in. We do have a question, John.
Oh, right. Okay, then.
Does CAR cover the client if they are taking affordable units part of a bigger block at practical completion?
Oh, interesting. I think probably I'm going to say it will depend on your policy wording.
Mm-hmm.
There's no reason, as far as I can see, why they shouldn't.
Mm-hmm.
But it's one of those that I would certainly check with your broker and read the policy wording on. There's no reason, as far as I can see, why that it shouldn't. But again, it's not worth the risk.
Yeah.
I hope during the whole series of talks I've given on insurance, don't assume that insurers will do anything. If you're not sure, ask them now.
Yeah.
Don't assume that they will, because the chances are they probably won't.
Right. Okay, hopefully that will cover it. Are there any more questions before we cease trading for the evening? Doesn't appear so. That's good. Hopefully that answered that question. As we said earlier, yeah, please feel free, email jon.sharp@fletcherday.co.uk. If you want to log in for next week, seminars@fletcherday.co.uk. And don't forget, if there's any of our seminars you've missed, you can catch us at Fletcher Day Law on our YouTube channel. Everything that is recorded is available for you to view and download, so you can catch up there. Okay, everyone, thank you very much for joining us, as always, and we look forward to seeing you hopefully next week. Thank you and good night. Thank you, Jon.